Whitebeard's most long-standing ties were to Strode, and they went back to childhood. The two men had been boyhood friends growing up on neighborhood farms in Amherst County, and their bond continued into adulthood. When when they practiced law in the same swath of West Central Virginia, Whitebeard and Strode were both involved in founding the colony. In its early years, Whitebeard served on the special board of directors while Strode handled its legal work. Whitebeard became close to Dr. Purdy through its association with the colony. He served on the colony's board when it selected Dr. Purdy to be the first superintendent, and the two men worked together on the colony business, including taking a joint trip to Indiana to investigate eugenic sterilization program. To investigate its sterilization program. In April, the colony had recognized Whitebeard's role in its history by co-naming a new facility for male inmates. Jeez, the Do Whitebeard Building in his honor. Whitebeard had moved to Baltimore to take a position with a bank, but he remained in contact with Dr. Purdy. Although he would be presenting Carrie in her challenge to the sterilization order, Whitebeard had a long record of support for sterilization. He had been chairman of the colony's board in 1916 when Dr. Purdy was sterilizing inmates without the benefit of a state statute. Whitehead, why was I calling him Whitebeard? What the fuck? Whitehead had supported the superintendent's expensive reading of existing Virginia law, and the following year, his final one as a board member, he strongly supported Dr. Purdy in his battle with the Mallory family. The litigation over Carrie sterilization presented a more complicated geometry than the usual situation of two adversaries facing off in court. Dr. Purdy, Strode, Whitehead all had close social, political, and financial ties. Further complicating the relationship was the fact that Dr. Purdy, who would be paying Whitehead's legal fees, Carrie was, in every way, the odd woman out, and Whitehead's performance would reflect this. His representation of Carrie in the trial and subsequent appeals would turn out to be, as the legal historian Paul Lombardo has observed, not merely incompetent, but nothing less than betrayal. The Amherst County Circuit Court scheduled a trial on Carey's appeal for November 18, 1924, that did not leave Strode and Dr. Purdy much time to put together their case. The hearing before the colony's board had been a relatively simple matter. Strode and Dr. Purdy had offered their uncontroverted account of the facts and showed that they had met the law's condition. The board, whose members all knew Dr. Purdy and Strode well, had been inclined to defer to their medical and legal conclusions, and it granted Dr. Purdy's petition unanimously. The trial would be more challenging. A county judge was different from a member of the state hospital board. He had no institutional loyalty to the hospital. Jeez, what an asshole. He had no institutional loyalty to the hospital or to the superintendent. His mandate was more broadly to ensure that justice was served. Oh, okay. Okay, I read that wrong, I guess. Even if the judge who heard the case in Amherst County had close ties to Strode and Dr. Purdy, which seemed likely, the case would ultimately be heard by the Virginia Supreme Court of Appeals in Richmond. And perhaps even the U.S. Supreme Court. Dr. Purdy and Strode would ultimately not be able to rely on their connections to the decision-makers to prevail. God. The biggest difference, however, would be in the law. The colony's board had accepted the validity of Virginia's sterilization statute. and only inquired into whether its previous provisions were met. A state court would start the question of whether the eugenic sterilization law itself was valid, and it might not be an easy one for Dr. Pretty and the colony to prevail on, as Strode had discovered when he researched the matter. When courts across the country had reviewed eugenic sterilization laws, almost without exception, the law had been struck down. The eugenicists had won the first such challenge in 1912 when Washington's sterilization law was upheld by the Washington Supreme Court. The tide, however, had turned quickly. New Jersey, home of Vinland Training School for feeble-minded girls and boys, had enacted a sterilization law, which had been signed by Governor Woodrow Wilson, the former president of Princeton, the future president of the United States. In 1913, the New Jersey Supreme Court ruled that the law violated the Equal Protection Clause because it applied to individuals who were in state institutions but not people in the general population with the same conditions. The next year, the Federal District Court in Iowa struck down a law that authorized sterilization of criminals. The court ruled that it was a bill of attainder, a law that pronounced people guilty without a trial, because it said certain categories of criminals had to be sterilized, leaving nothing, quote, for the person, leaving nothing for the prison physician to do but to execute the order. The decision was not directly relevant to Virginia's law, which required individualized determinations of who should be sterilized, but it was another ruling against sterilization, and one in which the court had expressed particular outrage at the barbarism of the procedure. God damn it. I'm just itchy for some reason. I don't know. In 1918, the court in two more states, New York and Michigan, had struck down eugenic sterilization laws. The grounds were the same as New Jersey, that the laws violated equal protections because they applied only to inmates of state institutions. Those rulings were relevant to Virginia because Strode had included the same limitations, and they were not helpful to the eugenic cause. The latest legal setback, in some ways the most discouraging one for the eugenicists, occurred when the movement began. In 1921, the Indiana Supreme Court had struck down the state's first in-the-nation eugenic sterilization law. The court ruled that 1907 law violated due process clause. In all, from 1913 to 1921, the 8 laws were challenged, and after the success in Washington, the eugenicists had lost in the next 7 states: New Jersey, Iowa, Michigan, New York, Nevada, Indiana, and Oregon. State and federal courts decided that cases on the variety of constitutional grounds, equal protection, due process, and cruel and unusual punishment. The rulings pointed to a range of problems with the laws, and they applied only to a portion of state's population, or did not provide sufficient procedural protections. Read on their own terms. The decisions suggested that the specifics of the statutes mattered a great deal, and laws were not drafted properly would be struck down. There was another way of reading the cases, however, as an expression of general societal unease with eugenic sterilization. There had been enough euthanization for sterilization that in the short period of time laws were adopted across the country. Nevertheless, it was not clear that not everyone was caught up on the eugenic mania, and the resistance was not just coming from the courts. In several states, the governors vetoed eugenic sterilization laws and delivered strongly worded indictments. Nebraska's governor insisted his state's sterilization bill seemed, quote, more in keeping with the pagan age than with the teachings of Christianity. And he declared in his veto message that, quote, man is more than an animal. Okay. The landscape for eugenic sterilization, which had been so promising in 1913, was now decidedly less so, and the judicial monumentum was. Oh, I read that right? And the judicial monumentum was strongly against it. Dr. Priddy and other supporters of the Virginia sterilization law would need to create the strongest possible case. They had drafted the law with considerable care, drawing on expert advice on how to make it resistant to constitutional challenge. They had chosen in Carrie Buck a plaintiff they believed demonstratedly particularly well why eugenic sterilization was necessary. Now they needed a eugenic sterilization expert, a respected academic authority who could persuade skeptical judges that the law and the sterilization order were necessary. In a letter to Dr. Purdy, Strode explained that they needed someone who could bolster their arguments with the most credible and convincing scientific evidence. Dr. Purdy agreed, and there was one name at the top of both men's list. It was the man who had written the treatise on eugenic sterilization and the model statute that Strode had relied on in drafting the Virginia law, Harry Laughlin.